Hello everybody and welcome to the second of the statutory interpretation videos, and this one, if you recall from the end of the introduction, is going to be on the rules of interpretation. And it's going to be, there's a level of complexity involved in the rules of interpretation, and so to try and help us to clear that in our minds, I've divided the canvas here into four, and each one of these areas that I've divided makes it very clear. We'll talk about one of the rules of interpretation. Okay, so that's why the page looks slightly different than it would normally. And remember, there are some key rules. Just to put them in context, the rules of interpretation are a guide for judges as to how they should go about interpreting what Parliament meant in statute. And there is a list and a set order. You'll recall from the last video that judges will always start using the literal rule. They will then progress on through the golden and the mischief rule. If the statute has been made by the European Parliament, they can only apply the purposive approach. I will go back over that as we go through the video, but just bear that in mind. They will always start with the literal rule. And the literal rule is precisely that. It tells the judges that the way in which they should interpret a word or a direction in statute is to give it its literal meaning. And by literal, we mean its ordinary and natural meaning. So the literal rule is about giving a word its ordinary and natural meaning, even if that word leads to an absurdity. Now, this goes back some time. Lord Esher, a judge in 1892, said, if the words of an act are clear, you must follow them, even though they lead to a manifest absurdity. And Lord Reid, in Pinner v. Everett, and that was a much later case, 1969, said, in determining the meaning of any words or phrase in a statute, the first question to ask is always, what is the natural and ordinary meaning of that word or phrase in its context in the statute? Now, as you'll see in a moment, the reason that this leads to an absurdity is, as we saw in the previous video, some words can mean many things, or, placed in the context, if you apply exactly what Parliament meant, you have to include the things that Parliament didn't foresee. A good example of this is Whiteley versus Chappell. Now, I appreciate this is an old case, 1868, but in Whiteley versus Chappell, the statute made it an offence to impersonate any person entitled to vote. So let's write that down. Impersonate any person entitled to vote. Okay, so the statute made it an offence to impersonate any person who was entitled to vote. The defendant used the vote of a dead man. Now, a dead man, of course, is not entitled to vote because he's dead. The statute requires, or relating to voting rights, require a person to be living in order to be entitled to vote. The judges apply the literal rule and the defendant is acquitted because he cannot possibly break the law because it was required that the person must be able to vote. So there we have the application of the literal rule, which leads to an absurdity. I'll show you some more of those when we look further, when we look at two more cases later. So let's just take a look at some of the general rules of the literal rule. Now, the first thing is it may lead to unexpected results. Okay, as you can see from the old peeling of that orange there. The literal rule may lead to unexpected results that were not the intention of Parliament. It was certainly not the intention of Parliament in Whiteley versus Chappell that impersonating any person entitled to vote would mean that people who impersonated dead people would get off, would be acquitted. What Parliament meant, was to stop people voting and using other people's vote to falsely voting. They'd missed that loophole, but the application of the literal rule led to an unexpected result. It's always, we've discussed this, the first rule applied. Okay? It should always be the first rule applied. As we've seen below, it requires the judge to give the words of the statute their natural and ordinary dictionary meaning. And it should be applied without the judge putting any gloss on it. So it should be applied without the judge seeking to put a gloss or on the words or to seek to make sense of the statute. This is straightforward. This is what it says. This is how I'm interpreting it. And that might mean that the case appears to be contrary to the rules of Parliament. Not always, but frequently the decision that's made could be contrary to the rules of Parliament, as we've seen in Whiteley versus Chappell. All right, so let's have a look at a couple of cases in which that is demonstrated. In R versus Harris in 1836, the defendant bit off the victim's nose in a fight. The statute made it offence to stab, cut, or wound. That's what the statute said. The court held that under the literal rule, the act of biting did not come within the meaning of stab, cut, or wound, as these words implied an instrument had to be used. Therefore, the defendant's conviction was quashed, not guilty. In Fisher versus Bell, the defendant had a flick knife displayed in his shop window, and that flick knife had a price tag on it. Statute, and the statute in this instance is the Restriction of Offensive Weapons Act 1959, made it a criminal offence to sell or offer for sale, such flick knives. Now the court applied the literal rule of statutory interpretation again. Now, I've got to go back and just fill in the blanks a little bit here. If you have done contract law, you will know very clearly that there is an offer to sell and an invitation to treat. An invitation to treat is not an offer. And in this case, the defendant's conviction was quashed because in contract law, goods on display in shop windows are not offers in the technical sense, but they are an invitation to treat. The court found the defendant not guilty, even though it was obvious that Parliament's intention to stop the sale of these types of weapons was inherent in the statute. So in both of those cases, the defendant walks free because the literal rule was applied and led to some element of an absurdity. Now you might say, well, why on earth do we use the literal rule? Of course, one of the key reasons is that Parliament is meant to be supreme. It's Parliament's job to change statute, to make statute, to change the law, to amend the law, not the judiciary's. It's the judiciary's job to interpret the law. So the literal rule gives you a good example of where judges are demonstrating very clearly that this is Parliament's intention and it's up to Parliament to make the changes, not us, because that's what happens in a democratic society. Parliament changes the law and makes the law, judges just interpret it. Now, not all judges, not all members of the judiciary subscribe to this, and we'll see that as we work through the different rules. So that's the literal rule. Let's go and take a look at the golden rule. The golden rule, which is applied after the literal rule, may be applied where the application of the literal rule would lead to an absurdity. So if the judge decides this is going to lead, if I decide this, it's going to lead to an absurdity, if they wish, they can then apply the golden rule. So the courts may apply a secondary meaning, and that secondary meaning may avoid an absurd result. And the case that you want that comes from is the River Weir. They're always long names, aren't they, when I'm trying to write them. River Weir Commissioners versus Adamson. And that's 1876 to 1877. It's a long old case. And what that effectively said is that in that case, in the late 19th century, is that the courts may apply this second meaning if it will avoid an absurd result. And there are two different types of the golden rule. There is the narrow approach and the broad approach, and they're both well illustrated by some cases. In the narrow approach, the narrow approach is applied when the word or phrase is capable of more than one literal meaning. Okay, so if there's more than one literal meaning, then the narrow approach is applied. And this allows the judge to apply the meaning that avoids the absurdity. Do you remember in the original video we talked about season, and how season can mean spring, summer, winter, autumn, or it can mean salt and pepper? Well, the narrow approach allows the judge to choose the one that is obviously applying, so the one that avoids the absurdity. The broad approach is applied where there is only one literal meaning. But applying that one literal meaning would cause an absurdity. Okay, so under the broad approach, the court will modify the meaning to avoid the absurdity. So in the narrow approach, the judge chooses the meaning that avoids the absurdity. In the broad approach, they narrow the one literal meaning to avoid the absurdity. Let's have a quick look at these two cases. The first is R versus Allen in 1872. And in R versus Allen, the defendant was charged with the offence of bigamy under section 57 of the Offences Against the Person Act 1861. Now, bigamy is when you marry more than one person. The statute states, whosoever, being married, shall marry any other person during the lifetime of the former husband or wife is guilty of an offence. Under the literal interpretation, the offence would be impossible. And the reason it would be impossible, and this is quite complex, so try and get your head around this. The reason it would be impossible is because you can't marry somebody if you are already married, because it's against the law. So if you can't marry somebody because it's already against the law, a second marriage is always going to be impossible because you're not allowed to do it because you're already married. So under the literal interpretation, the offence would be impossible to commit since civil law would not recognise a second marriage, and any attempt to marry in such circumstances would not be recognised as a valid marriage. And if it wouldn't be recognised as a valid marriage, then you can't be married twice. So through the golden rule, the court applied that the word marry should be interpreted as to go through a marriage ceremony. Therefore, it didn't matter whether or not you were married, i.e. you had a wife or a husband. What mattered in this sense is that marry had its other meaning about going through a marriage ceremony. And Allen's conviction was upheld. In Adler versus George, under the Official Secrets Act in 1920, it was an offence to obstruct a member of the armed forces in the vicinity, so let's look at these words, in the vicinity of a prohibited place. The defendant was actually in the prohibited place, rather than in the vicinity at the time of the obstruction. So If you apply the literal meaning, being in the place is not in the vicinity. In the vicinity means outside it but close to it, in the area. The court applied the golden rule again. It would be absurd for a person to be liable if they were near to a prohibited place, but not if they were actually in it. And his conviction is therefore upheld. Now, I've put one more here, just as a way of demonstrating, and that's Rhys Sigsworth in 1935. And in that case, a son murdered his mother. She had not made a will, and under the statute set in the law on intestacy, that is the law when what happens when somebody hasn't made a will, he was her sole heir, and therefore stood to inherit her entire estate. So because she hasn't made a will, all of her money goes to him, but he's the person that's killed her. The court applied the golden rule here, holding that an application of the literal rule would lead to a repugnant result. And they said that he was entitled to nothing. So you can see how the golden rule starts to remove those absurd results. The consequences of using the golden rule, though, because it seems relatively sensible on the face of it, is it leads to what we call judicial lawmaking. In all three of these cases above, you've seen the judge making a decision that changes the law. Now, if you truly believe, if you're an absolute purist in terms of democracy and the separation of powers, you know that the only person that should be allowed to change the law is Parliament. The golden rule starts to allow the judiciary into the process of lawmaking. The narrow approach allows judges to choose between several meanings. And finally, the broad approach, the one that we saw in the prohibited place, Adler versus George, the broad approach allows modification. Of the meaning of words. And you can see this fine gentleman here with some body modification going on, very bizarre. So those are the consequences of the golden rule. The most important, I think, for me, is that it allows judicial lawmaking. Okay, so it allows judicial lawmaking. They can choose between several meanings, and it allows, the broad approach at least, allows the modification of the meaning of words. Let's take a look at the mischief rule, the third of our rules. And the mischief rule is the oldest. This is the one that goes back the furthest. And the mischief rule is very clear. It's the court's role to suppress, this is what the advocates of the mischief rule would say, the court's role is to suppress the mischief the act is aimed at and advance the remedy. Now, what on earth does that mean? What that essentially means is that whatever an Act of Parliament was trying to put right, then the mischief rule would aim to carry out that request. So in order to understand decisions in the mischief rule, in order to make decisions according to the mischief rule, you have to look at what was happening before the Act of Parliament. So let's just take an interpretation of the Offences Against the Person Act in 1861. You would have to look at what was the state of the common law, what was the state of the law before 1861. The OAPA was introduced in 1861 to stop some mischief, to stop some things happening that were obviously wrong in society, that Parliament thought that it had to make an Act of Parliament. The mischief rule looks at that period of time before the Act was made. Now that's important because it's slightly different and will help me to explain the purposive approach in a moment. And you can see the key rules for the mischief rule come from Hayden's case. And look at the date of Hayden's case, 1584. That's how we know that it's the oldest one. And in that, we get some key rules. Remember, the court looks at the gap in the law that Parliament felt necessary to close. The gap is the mischief. It then interprets the Act to fill that gap and remedy the mischief Parliament had been aiming to remedy. Okay? And it does that by applying the rules from Hayden's case. So the first thing is the judge will look at what was the common law before making the Act. The second thing they'll look at is what was the mischief and the defect for which the common law did not provide, i.e., why did Parliament think it necessary to write statute? What was the remedy, what was the statute that Parliament passed to cure the mischief? And what was the true reason for that remedy? Okay, to illustrate that, we'll look at Smith versus Hughes. And Smith versus Hughes is a 1960s case. And in this case, the defendants were prostitutes. Okay, I hope I don't need to explain what they are. And they'd been charged under the Street Offences Act. Okay, let's write this down. The Street Offences Act, 1959. And that made it an offence to solicit, i.e. to ask for trade, in a public place. Okay, so the offence is soliciting, i.e. selling your wares, in a public place. Now, the prostitutes were soliciting from private premises, in windows or on balconies, so that they could be seen by the public. If you apply the literal rule here, even the golden rule, you will see that the prostitutes were not soliciting in a public place. So the judges looked as to what was the mischief that Parliament was trying to prevent. And quite obviously, in the Street Offences Act, Parliament was trying to stop prostitution. That was the mischief. Prostitution was the mischief. And particularly prostitution whereby prostitutes stand on the street and sell themselves on the street. So what the courts did is it applied the mischief rule, holding that the activities of the defendants were within the mischief of the Act, even though under a literal interpretation they would be in a private place. So in Smith versus Hughes, the court uses the mischief rule to be able to make sure that Parliament's will is followed through. Now, what are the consequences of this rule? Because again, it seems imminently sensible. We know that it's the oldest of the rules. Look at that old fella smoking a cigar. But unfortunately, once again, it allows for a far greater degree of judicial lawmaking, because it allows the judge to decide what they think Parliament intended to put right in the previous law. It may not be the case that that's what Parliament intended, but it certainly is going to be what the judge thought Parliament intended. And therefore, laws can be changed on the basis of what a judge thinks. Now, if the golden rule went against the principles of straightforward democracy and the separation of powers, the mischief rule most definitely does. So you have a balance, and the balance is, do you adhere to the separation of powers and apply the literal rule, but put up with absurd results? Or do you allow judges to make laws and avoid some of those absurd results, but unfortunately at the same time you then don't, or you move to a position where it's not Parliament making your law? So it's a very difficult balancing act. Let's finally look at the purposive approach. And in the purposive approach, this applies to all European law. And the aim is to produce the decisions which put into practice the spirit of the law. The court looks at the gap in the law that Parliament felt necessary to close, then interprets the Act to fill that gap and remedy the mischief Parliament had been aiming to remedy. Okay, so that's slightly different here in terms of what the judge interprets. I'm going to come back to that in a moment. It's driven by the European Communities Act, 1972. And in that, the UK courts, it says very clearly, the UK courts must give effect to European law, so should also use their methods. And the methods of the European law is to use the purposive approach. So when we are using EU law and we are trying to interpret EU law, because EU judges use the purposive approach, our judges have to use the purposive approach. Okay? So, let's take a look at a case. It gives us some idea about what we mean. And we'll look at R versus Rogers. Now, interestingly enough, that's just to relate that this is an old man. This is actually Ronnie Biggs, who recently died. But he's not the person, he's not the man concerned. But he's just a cantankerous old devil by the looks of it. And that's why I've included him in this. Because in Rogers in 2007, Rogers, who is incapacitated by arthritis, all right, so he has quite a severe debilitating illness. He was riding his mobility scooter along the pavement on his way home from a pub. 3 women were walking back to the home, or one of their homes, after a birthday party in a local restaurant. An altercation, a fight took place, a verbal fight, as Rogers tried to get past them on the pavement in his scooter. He then pursued them in an aggressive manner into a local kebab shop, where they had run away and hidden. And he called them bloody foreigners and told them to go back to their own country. The Lords ruled that Rogers had not only committed the offence under the Public Order Act of 1986 of using threatening, abusive or insulting words or behaviour, intending the victims to fear immediate unlawful violence or to provoke it, but that he had also committed an aggravated race offence under the Crime and Disorder Act 1998. Responding to the Court of Appeal's question as to whether those who are not of British origin constitute a racial group under the Crime and Disorder Act, Baroness Hale says the answer is yes, as it would be to question whether foreigners constitute such a group. So, the question you have to ask yourself is, would the same problem have existed if he'd used the phrase bloody Spaniards rather than bloody foreigners? Okay, so Rogers is relatively straightforward, and the purposive approach is relatively easy to understand, I guess. What did Parliament intend? What does the Act say? What did they mean by the Act? Then let's apply that. So it looks back. So in terms of this focuses on what Parliament intends. What did Parliament intend? And it's a modern version of the mischief rule. Okay? It certainly provides judge lawmaking, because the judge is allowed to decide what Parliament thought. Okay, and just to demonstrate the difference between the two, let me move up a little bit. Just to demonstrate the difference between the two, what you have is, if you imagine, this is the Act of Parliament, this is before the Act, this is after the Act. The mischief rule looked at this period here. All right, the mischief rule looked at this period here. The purposive approach looks at the Act itself. So the mischief rule will say what was going on before the Act, because that's what we'll try to make the ruling on. The purposive approach says what does the Act itself say. So although they really are doing the same thing, the purposive approach is probably going more towards what Parliament intended than the mischief rule did. And finally, you've got to ask the question is, how do the courts decide? How do the courts decide which one of these rules they follow? And the easiest way to say that is that it depends on who the judge is as to which rule and which case, or who the judge is and which case it is as to which rule they'll follow. And I've got two key judges here. One I had to sort of do a drawing of because I couldn't find his photograph. But the first is the famous Lord Dennin and the second is Lord Simmons. Lord Dennin said very, very clearly, we do not sit here to pull the language of Parliament to pieces and make nonsense of it. We sit here to find out the intention of Parliament and carry it out. And we do this better by filling in the gaps than opening it up for destructive analysis. Simmons, on the other hand, says, filling in the gaps is a naked usurpation of the judicial function under the guise of interpretation. If a gap is disclosed, then the remedy lies in an amending act. So Dennin very clearly would follow the mischief or the purposive approach, whereas Simmons would follow the literal or golden approach. Simmons believes it's Parliament's job to make law. Dennin seems to think that judges are more or should have a greater role in interpreting the law. I'll leave you to decide where you sit on that debate, but I'm hoping that it's quite a complex video lecture really. There's a lot going on in statutory interpretation, but if you go over and over it, once you've got it, it's very, very straightforward and simple to understand. Okay, remember these are rules. These are the starting point for judges to be able to make the decisions about how to interpret statute. What we'll do in the next video is we'll look at some of the aids that they use to apply to the rule that they've chosen.